Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. This week, we're tackling complicated matters of adverse credibility, aggravated felonies, mens rea, and motions to reopen, much of which comes from a trio of Ninth Circuit cases. But before I get started, I wanted to make you aware of a few things. First, for your researching pleasure, we've listed every single case discussed on the podcast with every single case note on the KKTP website. Just go to www.kkTP-law.com/immigration-review-podcast/ and click on the case summaries link. Then, you can do a simple control find and locate that special case discussed on the podcast that supports your argument. I hope to one day turn this into a giant database of all published immigration cases, so watch out, Westlaw. Next, and just a reminder, if your state bar is like Florida, or if your state bar is Florida, and allows for self-certification of CLE credits, and you'd like an official immigration review certificate to submit to your state bar, just email me at kgreg@kktplaw.com with the 10 episodes you've listened to and the date that you completed the 10th episode. For $20, we'll send you an official immigration review certificate for CLE submission. Next, just a note, 2 cases came out this week that I'm not discussing. One was from the 8th Circuit, and it's a bad naturalization case that arises in district court and not immigration court. I won't usually discuss cases like that on the show. Again, primarily because it arises in district court. The other case is simply an amendment to an 11th Circuit decision published a few weeks ago. I won't normally discuss amendments to decisions either, but congratulations again on your win in Rendon, Anthony Dominguez. And finally, stay tuned to the end of the show, where I will take my first listener question. And with that, on to the first case. First up is Iman v. Barr, published by the Ninth Circuit on August 25th, 2020. This case is about adverse credibility, and it's a good one. Mr. Imam claims he is a member of a minority Somali clan, and that he fled Somalia after members of a majority clan forced him to work as a slave for over 2 years, beat him, and killed his brother. He applied for asylum and related relief, but his application was denied because an immigration judge found that he was not credible, also known as an adverse credibility decision. The BIA affirmed. An adverse credibility decision is not quite the same as the judge saying that the non-citizen is lying. Rather, an adverse credibility finding means that the non-citizen hasn't met his or her burden to prove to the judge that he or she is credible, due to, say, inconsistencies, the non-citizen's demeanor, or even a lack of corroborating evidence. And inconsistencies in a non-citizen's testimony are sometimes understandable. After all, many immigration court applicants don't speak English. All of them are immigrants. Some are fleeing persecution during their encounter with U.S. immigration officials. And the government attorneys are usually pretty good at cross-examination. Many years ago during a training, I was even cross-examined in a mock case, and ended up testifying inconsistently in that mock case. But credibility is kind of like the gatekeeper to immigration benefits. If you don't pass it, you're probably screwed. And because the analysis is so fact-specific, it's really hard to get an adverse credibility decision overturned. But Mr. Iman and his attorneys pulled off a bit of a unicorn here and got the Ninth Circuit to agree that the IJ and the BIA erred holding that, quote, the totality of the evidence, end quote, does not support an adverse credibility finding. The crux of the issue was that when Mr. Iman first encountered immigration officials at the border, Mr. Iman told them that in addition to all the terrible things that he ended up testifying to in court, and that he submitted in his writing to the court, his sisters were raped by the Klan. But he never testified in court that his sisters were raped. When questioned about this omission in court, Mr. Iman said that he did not speak English well when he first came to the U.S. and encountered the immigration officials, and that he didn't have an attorney at the time. Also in court, Mr. Iman was apparently unresponsive to some of the questions asked by the government attorney and the judge. There were some other things, but that's the gist of it. Addressing first the unresponsiveness, the Ninth Circuit held that the IJ and the BIA must, quote, identify specific instances supported by the record where the petitioner did not respond, end quote. Because the IJ only stated that Mr. Iman was generally unresponsive, the IJ's decision doesn't cut it. As to Mr. Iman's failure to mention the rapes, even though Mr. Iman admittedly omitted this harm in his in-court testimony, the Ninth Circuit noted that, quote, omissions are less probative of credibility than inconsistencies created by direct contradictions in the evidence and testimony, end quote. And that, quote, the mere omission of details is insufficient to uphold an adverse credibility finding, end quote, particularly where the omissions are collateral to an asylum claim. In this case, the Ninth Circuit held that the rapes of Mr. Iman's sisters were kind of collateral to Mr. Iman's claim. After all, it didn't happen to him. But more importantly, and I think this is quite important, the omission was completely consistent with Mr. Iman's other testimony. It just added to it. So the omission wasn't really indicative of non-credibility. Quote, it strains credulity to think Iman wouldn't have mentioned his sister's rapes on direct examination if he was trying to artificially bolster his claims, especially because he had previously disclosed this information during his credible fear interview, end quote. This is an important quote, because adverse credibility decisions are often based on later in-court omissions just like this, that aren't actually inconsistent with prior statements, but are simply supplemental. The Ninth Circuit is saying in this case that omissions in court that would have been beneficial to the non-citizen are a weaker basis to make an adverse credibility finding. Great case for the wild world of credibility. Here's a bit more on responsiveness. Here's an interesting standard for circuit court practitioners to remember. Even if an immigration judge cites to multiple reasons for an adverse credibility finding, the Ninth Circuit, quote, does not review those parts of the IJ's adverse credibility finding that the BIA did not identify as the most significant and did not otherwise mention, end quote. This is a pretty friendly standard to non-citizens that should be argued throughout the circuits. Relatedly, before the Ninth Circuit, Oil tried to argue that another part of Mr. Iman's testimony was unresponsive and therefore supported the adverse credibility decision. The Ninth Circuit rejected this because, quote, neither the IJ nor the BIA referenced this testimony in their respective decisions, end quote. So don't let Oil rewrite the agency's decision, guys. And that is Iman v. Barr. Next is Aliyev v. Barr, published by the Ninth Circuit on August 24, 2020. This case is about what is required to file a motion to reopen with the Board of Immigration Appeals or an immigration judge, based on an application for relief from removal. When filing a motion to reopen with the BIA or an immigration judge, 8 C.F.R. Section 1003.2c1 and the respective immigration judge regulation requires that non-citizens attach, quote, the appropriate application for relief, end quote, to their motion. Mr. Aliyev sought to reopen his asylum proceedings based on new material evidence, as is his right under the immigration regulations. And with his motion, he attached the asylum application that an immigration judge had previously denied and that the BIA had previously dismissed. The BIA denied the motion to reopen, saying that in order to comply with 8 C.F.R. section 1003.2c1, Mr. Aliyev needed to attach a new asylum application, not his old one. The Ninth Circuit said that that doesn't make sense at all, because in all cases, a non-citizen seeking to reopen proceedings to apply for asylum is seeking to reopen his initial asylum application. In such cases, the non-citizen is only supporting new evidence in support of that previous asylum application. So there's no need for a new application, only new evidence. Or, in the Ninth Circuit's words, quote, "It makes no sense to require someone in petitioner's shoes to submit a new asylum application that is identical to the earlier application," end quote. And just for good measure, the Ninth Circuit held, in an unpublished decision issued the same day, that the BIA erred in alternatively holding that Mr. Aliyev did not establish changed country conditions in Azerbaijan sufficient to reopen his asylum case. So congratulations, Mr. Aliyev. 2 notes. First, the regulatory analysis in this case appears to be an issue of first impression. So practitioners, cite to the case in all the circuits and make some good law. And one last word of warning. The outcome might have been different if, say, the basis for Mr. Aliyev's asylum claim had changed from political opinion to particular social group. So be careful and maybe file a new asylum application if your client has those circumstances. And that is Aliyev v. Barr. Rounding out the Ninth Circuit's trio, we've got Yoon et al. V. Barr, published on August 25th, 2020. This case addresses the definition of the word perjury as used at INA Section 101A43S, the aggravated felony perjury definition. It involves 3 non-citizens with 3 sets of facts, and it's complicated, so we're going to stick primarily with the legal holding. In this case, the Ninth Circuit held that the BIA's definition of perjury in its 2016 decision, matter of Alvarado, defining a perjury aggravated felony to mean an offense where, quote, an offender makes a material false statement knowingly or willfully while under oath or affirmation, or penalty of perjury, where an oath is authorized or required by law, end quote, is a reasonable definition for perjury. So matter of Alvarado survives. The Ninth Circuit also held that perjury under California Penal Code Section 118A, the crime that all of the non-citizens in this case were convicted of, meets that definition. And here's why. To determine whether a state crime like Cal Penal Code Section 118A makes a non-citizen removable, the court applies the categorical approach, comparing the elements of the state offense to the elements of the federal removable offense. Here, the federal removable offense is an aggravated felony, defined at INA Section 101A43S, defined in relevant part as an offense relating to perjury. But in order to apply the categorical approach, you kind of need to know what the federal definition of perjury is. Otherwise, you don't know what the elements of the federal offense are. The BIA answered that question in 2016 in matter of Alvarado, holding that, quote, the generic definition of the term perjury requires that an offender 1. Make a material false statement, 2. Knowingly or willfully, 3. While under oath or affirmation, or penalty of perjury, and 4. Where an oath is authorized or required by law, end quote. Under the Supreme Court's 1984 C.F.R decision, circuit courts like the Ninth Circuit must defer to the BIA's definition of immigration terms if the immigration statute is ambiguous as to the definition that the BIA is defining, and if the BIA's interpretation and definition is reasonable. That's what the Ninth Circuit found in this case, with the BIA's matter of Alvarado decision as it relates to perjury as defined at INA Section 101A43S. Basically, the Ninth Circuit recognized that the BIA came to its perjury definition by reviewing common law, the Model Penal Code, the various state definitions of perjury in 1996 when the statute was passed, and the federal criminal perjury statute itself, and held that the BIA didn't mess up anything in its analysis. So, the Ninth Circuit deferred to the BIA and matter of Alvarado. Then, applying that definition, it held that California Penal Code Section 118A meets it. The case is a pretty statute-intensive analysis, filled with rejections of creative legal arguments made by non-citizen counsel. And if you have a similar state criminal statute that DHS alleges meets the matter of Alvarado definition of perjury, I urge you to look at this Ninth Circuit analysis and distinguish your client's criminal statute. A well-reasoned but not good decision for non-citizens. Here's one more note. Also not so good for crimmigration practitioners. The Ninth Circuit stated that, quote, the availability or unavailability of an affirmative defense is not relevant to the categorical approach, end quote, because we look only, quote, to the fact of conviction and the statutory definition of the prior offense, end quote. Relying on affirmative defenses that are unavailable at state law but available at federal law is one possible strategy used to show that a state conviction is broader than the federal offense, but the Ninth Circuit is rejecting it here. So keep that in mind. And that is Yoon et al. V. Barr. Moving on from the Ninth, we've got a case out of the First Circuit, Soto-Vittini v. Barr, published on August 24, 2020. This is a short and somewhat complicated case about accomplice liability and drug trafficking aggravated felonies. Mr. Soto-Vittini is an LPR, or lawful permanent resident, who, in May 2018, pled guilty to drug possession with the intent to distribute under Massachusetts General Law, Chapter 94C, Section 32A(a). The IJ and then the BIA held that this conviction constituted an aggravated felony, illicit trafficking in a controlled substance, as defined at INA Section 101A43B. Removability under Section 101A43B requires application of the categorical approach, which requires a comparison of the elements of the Massachusetts conviction to those of an illicit trafficking in a controlled substance offense. Mr. Soto-Vittini argued that, like many statutes, the Massachusetts conviction criminalizes accomplice liability in the same manner that it criminalizes principal liability, meaning that Massachusetts punishes those who help drug sellers in the same way that it punishes drug sellers. He then argued that the mental state, or mens rea, required of an accomplice under the statute is less than that required of an illicit controlled substance trafficking aggravated felony, making the state statute broader than the removable offense. Because again, according to Mr. Soto-Vittini, the state conviction for accomplice liability allows for a lessened mental state than does the federal illicit controlled substance trafficking aggravated felony. The First Circuit rejected this argument. It first noted that the Massachusetts statute requires that the defendant have an intent to distribute, and that the accomplice intentionally assist the principal and share his state of mind, which would be an intent. This, according to the First Circuit, is the same or the substantially similar mental state to the generic federal accomplice liability, which requires that an accomplice, quote, intend to facilitate the offense's commission, end quote. So according to the First Circuit, that means that the federal accomplice liability statute applicable to drug trafficking crimes is the same or substantially similar to that employed by Massachusetts, meaning that there is a match under the categorical approach. Like I said, a short, complicated, and succinct case. So on to the next one. And that is Soto-Vittini v. Barr. Sticking with the First Circuit, we've got Franjul-Soto v. Barr, published again on August 24, 2020. This is a case primarily about motions to reopen based on pending Violence Against Women Act petitions, or VAWA petitions. Mr. Franjul-Soto was ordered removed. While on appeal to the BIA, he filed an I-360 VAWA petition with USCIS, claiming a right to Violence Against Women Act classification based on abuse that he had suffered by his U.S. citizen spouse. If granted, Mr. Franjul-Soto may eventually adjust to lawful permanent resident status. But at the same time he was filing this petition with USCIS, he was also in removal proceedings. Before the petition was granted, an immigration judge ordered him removed, and the BIA dismissed his appeal. He then moved to reopen his appeal and his case with the BIA based on his pending VAWA petition with USCIS. He based his motion on the highly non-citizen-friendly statute INA Section 240C7C IV, which in relevant parts states that, quote, any limitation on the deadlines for filing a motion to reopen shall not apply, end quote, if the motion is predicated on VAWA eligibility and that certain other conditions are met. But the BIA denied the motion, noting among other things that Mr. Franjul-Soto failed to show that he was likely eligible for VAWA benefits, known in legalese as a prima facie evidentiary showing. The First Circuit dismissed the appeal of the denial of the motion to reopen. It held that the BIA properly requires a prima facie showing of VAWA eligibility, like with all forms of relief, before granting a motion to reopen on the basis of relief eligibility. According to the First Circuit, although the Violence Against Women Act is meant to be non-citizen friendly, it did not change the evidentiary requirements necessary to succeed on a motion to reopen, even if based on a VAWA petition. The First Circuit also held that the BIA did not abuse its discretion in finding that Mr. Franjul-Soto did not make a prima facie showing of VAWA eligibility. One note, and then we'll move on. On this last point, the prima facie showing, the First Circuit held that the BIA's rejection of Mr. Franjul-Soto's single affidavit of mistreatment, quote, which contained no dates and few specifics, end quote, was not error on the BIA's part because the affidavit alone did not suffice absent corroborating evidence. But if the affidavit had been more detailed, or if there had been other evidence of the specific claims that Mr. Franjul-Soto was making, the First Circuit might have held otherwise. So this case does not stand for the proposition that an affidavit alone is insufficient to meet a prima facie showing on a motion to reopen, just that Mr. Franjul-Soto's affidavit was not sufficient. And that is Franjul-Soto v. Barr. Moving right along, we've got Flores-Moreno v. Barr, published by the Fifth Circuit on August 24, 2020. This is another short case about motions to reopen. Mr. Flores-Moreno was removed in 2011, but he re-entered the country a few days later. He went to his attorney who had represented him and asked if he could appeal to the Fifth Circuit, but the attorney said that he couldn't because he'd been physically removed from the U.S. and then illegally re-entered. The attorney said that his office could do something that might help, but that it would take 3 years. 3 years later, with nothing having happened, Mr. Flores-Moreno went to another attorney, who said that nothing could be done. About 3 years after that, totaling about 7 years, a third attorney told Mr. Flores-Moreno that actually, he could have appealed to the Fifth Circuit through the first attorney many years ago. So Mr. Flores-Moreno filed a bar complaint against his first attorney, and filed a motion to reopen with the Board of Immigration Appeals based on his prior attorney's alleged ineffective assistance of counsel. The BIA denied the motion as untimely, and the Fifth Circuit agreed. Normally, non-citizens must file motions to reopen, even if based on ineffective assistance of counsel, within 90 days of the final removal order. The 90 days to file the motion can be extended through something called equitable tolling, if the non-citizen shows, quote, 1, that he has been pursuing his rights diligently, and 2, that some extraordinary circumstance stood in his way and prevented timely filing, End quote. Here, the Fifth Circuit held that at a minimum, the 3 years between Mr. Flores-Moreno waiting before he contacted that second attorney shows that he did not act with sufficient diligence. So, having found that there was no reason to extend the 90 days to file a motion to reopen, the Fifth Circuit denied Mr. Flores-Moreno's case. Short and fact-specific case, consistent with a lot of law. Here's one note. For circuit court jurisdiction nerds out there, the Fifth Circuit begrudgingly held that under the Supreme Court's recent decision Guerrero-Las Bria, quote, because there is no dispute as to the underlying facts, but rather only as to the application of a legal standard to those facts, end quote, the Fifth Circuit had jurisdiction to review Mr. Flores-Moreno's equitable tolling arguments, notwithstanding his serious drug conviction. So again, practitioners, remember, the application of a legal standard to undisputed facts is now a legal question that all courts must review, no matter the criminal history of the non-citizen. And that is Flores-Moreno v. Barr. Our last case before turning to a listener question is Romero v. Attorney General of the U.S., published by the Third Circuit on August 25, 2020. This case is about the reasonable fear standard applied when DHS reinstates a prior order of removal, but the non-citizen claims a fear of returning to his or her home country. Mr. Romero entered the United States in 2011 with a fraudulent U.S. passport and was expeditiously removed to Mexico, which means that DHS removed him, as is their legal right in certain circumstances, without giving him an opportunity to go before an immigration judge. Even though the procedure is called expedited removal and does not involve a judge, the result is a final order of removal with the same legal consequences as if the individual had appeared before a judge. 2 years later, Mr. Romero re-entered the U.S. without authorization, and in 2019, ICE discovered him. Instead of putting Mr. Romero in removal proceedings as an individual present without admission or parole, DHS reinstated the 2011 expedited removal order and sought to remove Mr. Romero without giving him an opportunity to go before an immigration judge. But Mr. Romero claimed a fear of returning to Mexico, so he received what's called a reasonable fear interview. Had he passed his reasonable fear interview with USCIS, he would have been able to appear before an immigration judge to apply for withholding of removal or torture convention protection. But the USCIS officer determined that Mr. Romero had not established, quote, a reasonable possibility, end quote, that he would be persecuted in Mexico on account of a protected ground under immigration law or by the Mexican government. As is his right, Mr. Romero appealed that narrow finding to an immigration judge, who agreed with the USCIS officer. Mr. Romero then appealed that finding to the Third Circuit. Just to take a step back, what Mr. Romero is appealing is a finding by a USCIS officer, not necessarily an attorney, which was affirmed by an immigration judge, that he does not have a, quote, reasonable possibility, end quote, of eventually, were he to be given a full hearing and time to present his case, of establishing his eligibility for withholding of removal and torture convention protection under immigration law. If that sounds weird and kind of standardless, it's because it is. So again, Mr. Romero is not appealing a full finding that he doesn't warrant protection or withholding of removal. He's appealing the preliminary finding that he shouldn't even be given the opportunity to apply for those forms of relief and protection. Also, for years, the circuit courts didn't have jurisdiction to review no credible fear or no reasonable fear findings. But a couple of years ago, the dam broke, and now circuits, including the Ninth Circuit and the Third Circuit, have held that they do have jurisdiction to review such claims. And so, while the Third Circuit reviewed the USCIS and immigration judge's finding that Mr. Romero failed to show a reasonable possibility of establishing eligibility for withholding of removal or torture convention protection, the Third Circuit ruled against Mr. Romero. Essentially, it agreed with the immigration judge and USCIS officer that his fears were the result of a personal conflict with his wife's ex-boyfriend, and not for any reason recognized under immigration law. It also agreed that the record did not show a reasonable possibility that Mr. Romero could show eventually that the Mexican government would torture or acquiesce to the torture he feared. So, Mr. Romero's prior and reinstated order of removal will be executed. One comment, and then one note on the always riveting standards of review. First, the comment. Mr. Romero was given a reasonable fear interview and not a credible fear interview because under immigration law, because DHS reinstated his prior order of removal, Mr. Romero was only potentially eligible for withholding and protection under the Torture Convention. As withholding and Torture Convention protection are more difficult to obtain than asylum, the reasonable fear standard is higher than the credible fear standard, applied in asylum cases. And the note. Although ultimately an unfavorable outcome, the case does make some decent law on the standard of review for courts to apply for credible and reasonable fear cases. The Third Circuit reviewed the immigration judge's decision for substantial evidence. Far from a favorable standard, but much more favorable than the standard urged by Oil, known as, and I'm not making this up, the quote, facially legitimate and bona fide reason standard, end quote. Whatever that is, and in all fairness the Third Circuit does explain, it's gotta be worse than the substantial evidence standard. So I guess the immigration bar dodged a bullet here. And in rejecting this standard, the Third Circuit agreed with a prior Ninth Circuit decision. And that is Romero v. Attorney General of the U.S. As I mentioned, before ending the show, I wanted to share with you all a question I received from a non-attorney listener. He asked a simple question. Why is it so hard for the people you discuss on your show who are trying to become U.S. citizens to simply not commit crimes? It's a good question, and it's a fair question. And it's one that every immigration judge, and if we're being honest, immigration attorney, has thought at one time or another. But the answer is complicated, and the question is a bit problematic, riddled with some assumptions that, if left unaddressed, may dangerously play into a larger narrative about immigrants. For example, statistics show that non-citizens are far less likely to commit crimes than are U.S. citizens. At the end of the day, some non-citizens make indefensible bad decisions. Others are bad people. Still others, like all U.S. citizens, are products of their environment, which for immigrants are disproportionately poor and violent. Think Robert De Niro in Godfather 2. But many are young, and have sometimes lived in the U.S. since infanthood, identify as Americans just like their neighbors, and make the same stupid mistakes in their youth as U.S. citizen adolescents do every day. But only the non-citizens face immigration consequences. One final important thing that I feel obligated to say. The podcast discusses a lot of cases involving criminal non-citizens because those are the cases that make their way up to the circuit courts of appeals, and those are the types of decisions that the circuit courts decide to publish. As I've said before, the U.S. government cannot appeal to the circuits the thousands of non-citizen wins that occur each year, often involving non-citizens without criminal records who do amazing things for this country. And of course, I don't discuss the many published criminal decisions out of the federal and state courts that involve issues related to U.S. citizens who've committed crimes, because this is an immigration podcast. So that, dear listener, is my best answer to your question. Thank you very much for listening. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.